right, go for it.
Good afternoon, everyone. Thank you for joining us at our second post-adoption training for the Unified Development Code. Appreciate you spending some time with us this afternoon and hope to make this of value for you. This afternoon, we are going to be going through information specifically about applications and how review happens and public participation. But we'll start off with where folks can find the new code. There's been some changes in the last little bit. The city now has posted on its Unicode website, as outlined in blue, is the new UDC, and then outlined there in green is the code that we've been living with for a while. And it's going to take a little time for Unicode to codify this and get it all queued up and ready to go with the online version in the standard format we're accustomed to. So until that happens, you can find the UDC there in the area outlined in blue. The zoning map accessibility has also changed. Our GIS department has added the new code that takes effect on February 1st to the community development viewer. So you can click the zoning button and you'll have a choice to display either the historic zoning that we've had for the last few years or the February 1st zoning. And so you'll be able to go to an area of your interest and be able to see either one of those projects that you might have an interest. And then you can, of course, continue to display planning projects or other information that is available through the community development viewer. So that has rolled out here recently. So looking at the UDC effective date, that will be on February 1st. So this Sunday, the new ordinance takes effect. And as we continue with the review of a variety of applications that have been submitted, if an application has been deemed complete, meaning that all of the necessary information has been submitted to the city, then that determines which set of regulations apply. So if the determination of completeness was prior to February 1st, then the project will finish out its review and construction under the old regulations. And if it is deemed complete after the effective date or after February 1st, then the new regulations will apply. So we will continue to see some projects moving forward and going to construction that were underneath the regulations that will be replaced. So as I mentioned this afternoon, we are looking at the process section of the Unified Development Code. There's a lot of different elements and parts that make up the Unified Development Code. Processes are a significant element of that, which are strongly influenced by state law. The state recently, in 2023, replaced our authority to do zoning and subdivision review and planning, and has given us new processes, and so we are implementing that with the Unified Development Code update. In the state regulations, there's kind of two large classes of projects. Ministerial, which has a specific definition, and then everything else, which we've chosen to call non-ministerial, just to hopefully make it clear it is or isn't one or the other. Ministerial projects tend to be smaller, less complicated projects, or else the finalization of something that has previously been reviewed. And we're simply looking to verify that all of the prior actions have been completed that were required to be completed. So things like a final plat, for example, and we'll talk more about those later. Non-ministerial projects are the ones that we're more accustomed to seeing in public review. So things like subdivisions or site plans, variances, things where there's some question about, in the case of a variance or deviation, whether the standing rule will be applied or whether there will be some sort of difference from that, or if we're making the rules, like amendments to the map or text, or if there are impacts which we just haven't analyzed yet. So the city does a lot of planning work in identifying impacts of growth through our land use plan and through our issue plans for parks and sewers and transportation and many other kinds of things. But we can't get to all the detail level at that high level analysis. So we have continuation of review for more detail work, and we carry that forward through these non-ministerial project reviews. As I mentioned, the state is the one who defines what a ministerial project is. All projects are subject to a variety of submittal materials. This is the information that the applicant has to turn in that helps us to understand how they have complied or how they believe they have complied with the standard and the things that are applicable to that kind of review that they're asking for. These applications traditionally and continuing forward are modular. So there are some kinds of projects which, depending on their particular site, may or may not have certain elements involved. And so the application setup is allowing data to be included or excluded depending on its presence and relevance. So for example, you can see the second line there is stream bed, stream bank, or wetland permits. So if there is a site that has no streams and no stream banks and no wetlands, then you do not need to provide that information. If you do have one of those, then there's an extensive checklist of materials that is required to be turned in, and becomes part of the review. Each of these items, as I mentioned, is looking at the next level of detail. We're not recreating work that was done through the facility plan, the issue planning or land use plan process, but we are diving into further details. So as we're looking at any of these kinds of applications, the state has defined kind of a basic level of review. And this is the ultimate decision that the review authority makes in order to say yes or no to an application. The Montana Constitution identifies that there are both rights and responsibilities that come along with development and participation, and strives to balance that. And zoning is part of the means by which we look at that balance and decide where somebody is using property in a reasonable way and where something might go too far. And so as you can see, this language, this is a direct quote from the statute, there's a heavy reliance on compliance with the applicably adopted zoning regulations, map, and subdivision regulations. So the real point is, did they follow the rules that have been established? And when we're looking at substantial compliance as a municipality, if there is a numeric standard, such as a 5-foot setback or something like that, substantial compliance would be meeting that setback. Not 4.5 feet is close enough, but 5 feet is 5 feet. There are other standards where there's less clearly defined quantitative measure, in which case there's other ways of evaluating those particular projects. When we're looking at any project, whether it's a subdivision or site plan, site zoning related project, there are 8 articles within the Unified Development Code that lay out the general items that we have. Article 1 establishes a general framework for the document. Article 2 describes individual zoning districts and certain standards like setbacks and building heights and things like that. Article 3 is land use, so the what is happening, not just in what kind of a building is happening. Article 4, community design, is oriented at the higher level elements. Where does the park go? What does the park look like? Where do the streets go? Those kinds of things. Article 5 is focused on site and building design. Article 6, as it says, natural resource protection, so wetlands, water courses, floodplains, things like that. Article 7 is the process components, and we're going to spend most of our time discussing that today. And then Article 8 is definitions. So diving into reviews. First of all, we're going to start talking about ministerial reviews. These tend to be the simpler processes. So this is the flow that an application comes through. It comes in through the city. It's checked initially to make sure that they have turned in the material or appear to have turned in the material. Gets assigned to a staff member who reviews it in further detail. They determine whether all of the necessary information has been complete. And then is, as outlined in pink there, that's the determination of substantial compliance stage. So first of all, we have to decide, do we have all the information to do the review? And then subsequent to that, we make a determination that yes, the application does or does not meet the requirements based on the information that's been provided. We then do the staff findings, depending on the kind of application. Sometimes that's simply an approval of a building permit, or it may be something more detailed, and then that moves on to a final decision. So I would like to note that building permit review, building code review is not part of zoning. It's we coordinate those two things, but it is its own set of legal authority, both at the municipal and the state level. And so when we are doing a review for anything related to building code, it is related, again, to the building code, not to the zoning. So as an example, with this sketch plan, this would be an application that someone turns in for a building permit. We are checking it for zoning compliance, but what we're checking for are zoning standards like setbacks and building heights and other things that are outside of the building code. The planners are not looking at things like joint details or roof tie downs or any of those kinds of things. That's solely the jurisdiction of the building code reviewers. When we move into more complicated projects and we're getting out of those ministerial permits, we're into our non-ministerial category. There's kind of two different tracks. We still continue in the law to have a difference between subdivision and zoning-based reviews. There's a considerably more parallel process than there has been in the past. Both of them start off with a high-level, non-binding review, in this case called a concept or pre-application, depending on the process you're in. The idea of that review is to identify high-level issues, critical path, what's the most concerning things. It's the opportunity where someone can make a request as an applicant and say, I know your checklist asks for this particular information, but I believe that it's not relevant to my project because, and then we can evaluate that request, and then that influences the submittal that comes in for the formal review at the plan review or preliminary plat. That's where there's a binding review process. This is where any noticing will occur that may be applicable to the project, and then a decision will be made by the community development director, who is the planning administrator. That's a change in the law. Previously, things like preliminary plats went to city commissions. Action that has been modified. So if it's a site development project, the decision gets made at the staff level, subject to appeal. And then the last step for things like a final plat, that's very traditional. Folks are putting in infrastructure or doing other things in between the preliminary and final plat stages. And they're showing that they have completed all of the required steps and conditions that may have applied to their preliminary plat. With a zoning-based review, final plan typically does not authorize any construction. It just completes the zoning review. So although it is a similar three-step process, it does not authorize the beginning of construction. That either follows up with a further review by infrastructure review or building code, building permit, or something of that nature. But the final plan review is checking to make sure that any outstanding items or conditions of approval, such as granting of an easement or something like that, has been completed before things move forward. As I mentioned, the substantial compliance determination is the one that applies. And so we're looking at compliance with the regulations at the zoning map, zoning regulations, and where applicable, subdivision regulations. And there is some latitude, as you can see here, where it says complies not strictly and rigidly, but substantially. So the code has a variety of elements of flexibility built into it. And so when we are applying the code, we're looking to ensure that it meets not only the letter of the law, but also the purpose. So looking at the flow for a site review, whether that's a subdivision or zoning project, this would be for something like a preliminary plat. It follows this kind of general stage. So application comes in, it's screened, we make sure it has the basic information. It bounces to the Development Review Committee, DRC. That's the collective staff, so engineers, fire department, parks department, planning, just the whole crew of us are checking our individual areas. And the first thing we're looking at is to ensure that we have received all of the necessary information for us to conduct our review. If we do, then we determine it to be complete. If not, then the application is paused. The applicant is informed of the deficiencies, and they have an opportunity to supplement their application. And we repeat that until all of the necessary information has been provided. Once it's been provided, then we can do our determination that the application is or is not in substantial compliance with the code. If it's not, then we can direct the applicant to make corrections. If it is, then we move forward into the staff report. This is a bit of a change in the practice. These days are under the new code. The staff report will be written before the notice. It will document the review that's happened and will disclose to the public the findings that the staff has made. And then that will support the notice period. Notice period comes in, it is a minimum of 15 business days. The type of notice we'll talk about in a minute. There's an opportunity for folks to submit written comments on whatever application it may be. They can focus on the criteria that are adopted in the code because the step that follows completion of the notice period is a review of the comments. So staff evaluates each comment. We look at the substance of it. Is it expressing an opinion, or is it providing a factual argument? If it's providing a factual argument, we evaluate it to say, is there information which shows that the project is not satisfying the requirements? If it reaches the fact that staff concludes that it is still in substantial compliance, then it moves on to the director decision. If it is not in substantial compliance, the application pauses review, information is requested from the applicant, and then a repeat of this process follows only on the new information. And so eventually we reach the point where the director is able to reach a conclusion and make a decision for the project. As I mentioned, this can apply to a variety of different kinds of projects. Example of a plat here for the Nexus Point subdivision, where they are dividing a larger piece of property into smaller pieces of property. Things we'd be looking for with this kind of an application would be things like street layouts, park locations, whether the lots have proper dimensions for future development, separation and avoidance of wetlands and water courses, or mitigation of stormwater, a variety of kinds of things like that. We would not be looking for any kind of information on vertical construction at this point. We're really looking just at the ground level and the utility type information. A site plan, that's where we're looking at the building design, the individual site design. We're looking at a higher level of detail. So we're looking at building elevations, maximum heights, parking requirements, all those kinds of things come into play with something like the site design. And then based on an approved site plan, folks are able to move ahead into building permit submittal and review. So a change in the Montana Land Use Planning Act, there's been more of an emphasis on doing planning at the beginning. That planning then influences and generates the basis for your zoning regulations. If there are elements that the zoning does not address, then you can deal with it at the subdivision level. State law lines out subdivision regulations are primarily focused on A, compliance with the zoning, and then B, elements related to things like surveying and recording of documents, the actual platting process itself that creates the parcels. And compliance with those regulations is what leads to the project decision. Like I mentioned, there's the 8 articles that we have in the code. When we are looking at review of any individual application, when folks are wanting to offer comments, we strongly encourage them to tie those comments directly back to code language. That is what is most effective in being able to support a change or a modification to a project. If it's a difference of opinion or a preference for a different policy, that really isn't a basis for the staff to make a modification to a site project review. If we want to have a conversation at the policy making level, then we can absolutely have that, but that's a different process away from individual site development. So when we're doing any of these kinds of things that are these non-ministerial projects, there's going to be a public notice of some sort. There is language specifically from statute. There you can see the citation, section 106, that sets a certain amount of minimum procedures for public noticing. And then the city has implemented through Division 730 in the UDC, our local noticing. So what is the content of the notice? When do you distribute it? How do we distribute it? How far do we distribute it? And we have coordinated with other kinds of reviews. Things like floodplains are also included inside of Chapter 38, but they're also subject to their own sets of laws that require certain kinds of noticing. So if you're browsing through the noticing provisions, you might scratch your head and say, why are floodplains treated differently? That's why. They have their own set of regulations that they have to satisfy. So when we are considering public comment, the area here that we're really looking at is there in bold, whether there are new or significantly increased potential impacts that have not been previously identified and considered. So that identified and consideration may have been, excuse me, may have been through the land use plan, may have been through a subject-specific issue plan like the Pratt, or it may be through the zoning regulations, the subdivision regulations, or the material that's been explicitly provided with an individual application. So as I mentioned before, we're looking at compliance with the regulations, compliance with the planning documents, not an argument over whether a commenter agrees or disagrees with the adopted policy. The method of notice does change depending on the project. Some are simply posted. Others have mailed notice. Some others have requirements for publication in the newspaper or on the website. So that does vary. You can look at the table 38 730-020, and it will break down the type of notice required by individual projects. So I mentioned that the staff report gets published prior to the public notice process. In that staff report, you're going to see findings made by the director. You're going to see the staff's analysis of how an application has complied, if there are corrections that need to be made, those kinds of things. The way we do this analysis is going to be different now than what folks may be accustomed to. So, for example, for a long time, there were what were called the primary review criteria in state law. There were 6 of them that we reviewed major subdivisions for. Those have all left the law. And so the nature of the staff report is going to look a little bit different than what folks are accustomed to. We still have to do factually based findings. We have to document our expectations and compliance. So those things are staying forward, staying in the code and moving forward. We can, in our review process as the staff, determine that there are necessary conditions of approval. So the code as adopted is a minimum requirement, and we can, on the basis of fact and information, determine that the minimum requirement is not sufficient to mitigate the impact of a particular project. If that's the case, then we can identify a condition of approval where some extraordinary action needs to be taken. The word extraordinary is very deliberate there. There's a lot of obligation on the city to justify why those conditions are put in place. And there is language that's been developed over many legislative sessions and court cases guiding us in when and how we apply those kinds of things. One of the other differences that folks might see in a staff report for a subdivision or a site project is a distinction between a condition of approval and a code requirement. So a code requirement is an identified thing where the staff has found a deficiency in the application, or maybe it's something that hasn't been finished yet, like the recording of an easement. We know what the standard is. The standard is applicable. It is the law. We don't have to justify its existence. That was already done when the code was adopted in the first place. And so that might call out a future action that will happen prior to a final plat, for example. And that would be different from these conditions of approval that I was just describing. When we're looking at individual site reviews, the way the code is structured is a little bit different. Folks are accustomed to seeing site plan review criteria being referenced. In this case, the code has been modified to make it clear that the code requirements are throughout the entire body of the code. When we're writing a staff report, when we're looking at the criteria, we're looking at the main text itself. There's not some extra layer. So the title of the section has been modified to Plan Review, Decision, and Record. And it basically creates the table of contents and to make it an orderly review for consistent reading and function. But it does not have any longer special criteria over and above what might be in Article 5 or Article 4 or whatever, wherever. So when applications go through the process and are approved, it's not uncommon that someone may determine that they need to make a modification to that. Sometimes that's because certain materials are not available, or there's additional information that becomes available that persuades them that they should make an adjustment. The code provides for adjustments to application types. And these 4 sections that you see on the screen are the biggest sections that govern that. If there has been an individual application of a condition of approval to a specific application, then if the applicant is asking for a material change, and there's some description in the code about that, it requires a re-review of the project through whatever was the original process. And that's the same for a subdivision or a site plan. If we look at 38-500-020, that's looking at when somebody's making a modification or a revision to a project or an existing property, when additional criteria related to site and building design may kick in. 740-120 is looking at amendments to plans. So somebody went through the plan process, they've identified a need for a change. There is opportunity for that. There's limitations. If you go above those limitations, then you again have to go back through the entirety of the review process. And then lastly, there, 750-090, that's a new thing from state law. If folks are modifying the plat, preliminary plat, so that it changes 6 or more parcels, then that requires a re-review of the subdivision. So parts of MLUPA simplified some process. In this case, that 6-lot modification was a more restrictive process that the state has established. And then lastly, as far as the frequency of applications, are legislative processes. So these are text amendments or amendments to the zoning map, very similar to a site development review, the difference being who's participating. The first part of it is the same, comes forward, is reviewed, staff writes the report, the notice goes out, but now we have the Planning Commission, also known as the Community Development Board, and the City Commission, who are partners in the review. Planning Commission makes a recommendation up to the City Commission, determining whether the application is in substantial compliance with the necessary criteria. And then City Commission makes an approval, and then they have to implement that by adoption of an ordinance. This is the process that probably changed the least as a result of MLUPA. But similar to the other pieces, if there's a determination that the submitted application is not in substantial compliance, it does cause a pause while additional information is gathered and made available for review. One thing that is different from a legislative process, whether that's the map or the text, is the city cannot establish a condition for a text or map revision. So that's just a distinction between these kinds of processes and other review processes. Other changes related to this are that there is no longer a protest provision. The state took that out. So a simple majority of the City Commission decides the issue, whatever they're being asked to vote on. Public notice is a little different for legislative processes. There's more of an emphasis on engagement at this level. As part of that, we have expanded the notice provision so that there's a bigger distance out, an extra 100 feet out, that get mailed notices for proposals. And that concludes my presentation, and I'd be glad to take questions.
All right, we have one already.
Great.
I'll just read it out loud. It may be quite informative to have Chris indicate the average/estimated timeframes applicants can expect for various types of applications: annexation, subdivision, site plan, and ministerial, simple home lots, etc. It shows just how much review actually happens to some that think it is a rubber stamp process.
That is a good question. That's not one I can just do totally off the top of my head. I can give some general guidance. Typically, if somebody comes in for an annexation and the zone map amendment that comes along with that, we will give guidance to folks that it usually takes 6 months. That's been our past experience. We expect that to probably continue to provide time for public hearings and things that go along with that. So that's pretty much that one. As I showed on the screen, there's a lot of different steps that occur. And each of those is a fairly detailed process. Let me slide back up to one here. There we go. So typically, DRC review, we're getting into that a week or two after the application's first been submitted. Determination of substantial compliance is probably in the 15 to 20 working day category. We need a little time, so probably a couple weeks to write the staff report, the notice. Again, it's 15 working days, so practically that's roughly a month by the time you publish it and make it available. We have 10 days to review the public comments that have come in and to determine if they are substantially in compliance, and then to be able to issue a decision. So if you stack all that up, I haven't added up the days, but it is a fair amount of work that the city puts into reviewing each individual application. And if it's a project that needs a DRC review, like a subdivision, you may have 10 or 15 different city staff who are weighing in and looking at different elements of that application. So they do get a great degree of scrutiny. And if you haven't read through the submittal list, zip up quick to that. If you haven't read this list, I suggest you go take a look. It's very, very exhaustive, the materials that the city requires folks to turn in for us to be able to do our review and identify that impacts have either been avoided in the first place, which is ideal, or mitigated as they move forward.
The next one is just a comment. I think it just says CCOA notice. So I don't know if Susanna was referencing something that you were talking about, but that comment was made.
Okay. That's where you can look in tables 38, 730, 020-1. Let me see if I can just pull that up quickly here. There we go. So this is the table in the code that calls out different kinds of applications. And so it breaks out ministerial and non-ministerial permits, identifies the kind of permit, and then the types of notices. So that here's something like a final plat that identifies that no, we don't do a notice for a final plat. Other things, site plans, preliminary plats, that's where you start seeing further detail where things are being posted on site or mailed or elements like that in the review process. When folks are wondering what the content of that notice is, that is up here in 730.010, and that did not materially change between the prior code and the new code.
Okay, the next question. Could you speak to what projects will go to commission for approval and if the commission can still reclaim projects?
The city commission will see anything that is a policy making process. So things like zone map amendments and text amendments will go to them. The adoption of a land use plan or an issue plan, which is both of those are outside of Chapter 38, but they're important and relate to it. Those also go to the city commission. There is no longer an opportunity to reclaim. That's something that the state made very plain, that original decisions are always made by the staff for things that are not text amendments and map amendments. Appeals can eventually get up to the city commission. Those are now a two-step process between staff to community development board to city commission, but no reclaims.
And I'm showing no further questions.
Okay. Well, we'll let folks think for a minute, see if they have something else pop up. Otherwise, we'll all get a few minutes back for lunch. This isn't the most riveting part of planning is dealing with process management, but we all get to deal with it when we have an interest in a project. So we're glad to be able to visit with you about it.
And one more question. Is this the last UDC education session?
It is the last one that we have a schedule for. We'll probably wait a little bit of time and see where we're getting questions from the public and if we think we can effectively answer those in this kind of a shared group. If so, then we will do some more. Otherwise, we'll just be able to answer one question at a time. So if you have areas you'd like us to weigh in on and do some training for, please let us know. We're happy to take suggestions. Okay. Well, if that's all our questions for today, thank you for everyone who has joined us. We appreciate your time and we hope you have a great day.
Great. Thanks so much.